What we're talking about today is the real constitutional Republican form of government that we're supposed to have and we don't have. And we haven't had real constitutional government since 1861. Uh, when the southern states decided to withdraw from the Union no longer had a quorum, and without a quorum, they couldn't have a Congress, so they closed Congress. And Lincoln said, no, 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 no. We have to have a Congress. I have to have you guys doing the work that I need done. So they opened up Congress without a quorum for just the Union states that were left. Down in the South, they formed a confederacy and they wrote their constitution. And all that the South did was legal. They didn't do a single thing that was illegal or unlawful. There's a difference there. Uh, but when Lincoln decided to put the states back together, and then somebody fired on somebody, and who knows what really happened. But that's when the undeclared war happened between the states. So since that time, we've been dealing with martial law. Since Lincoln wrote Executive Order 100 and the Lieber Code, we've been under martial law.
Ex parte Milligan, 71 U.S. 4 Wall 2, 1866, was a landmark decision of the U.S. Supreme Court that ruled the application of military tribunals to citizens when civilian courts are still operating as unconstitutional. In this particular case, the court was unwilling to give President Abraham Lincoln's administration the power of military commission jurisdiction, part of the administration's controversial plan to deal with Union dissenters during the American Civil War. Justice David Davis, who delivered the majority opinion, stated that martial rule can never exist when the courts are open, and confined martial law to areas of military operations where war really prevails, and when it was a necessity to provide a substitute for a civil authority that had been overthrown. Chief Justice Salmon P. Chase and 3 associate justices filed a separate opinion concurring with the majority in the judgment, but asserted that Congress had the power to authorize a military commission, although it had not done so in Milligan's case. The landmark case stemmed from a trial by a military commission of Lambton P. Milligan, for whom the case is named, Stephen Horsey, William A. Bowles, and Andrew Humphreys, that convened at Indianapolis on October 21, 1864. The charges against the men included, among others, conspiracy against the U.S. government, offering aid and comfort to the Confederates, and inciting rebellion. On December 10, 1864, Milligan, Bowles, and Horsey were found guilty on all charges and sentenced to hang. Humphreys was found guilty and sentenced to hard labor for the remainder of the war. The sentence for Humphreys was later modified, allowing his release. President Andrew Johnson commuted the sentences for Milligan, Bowles, and Horsey to life imprisonment. On May 10, 1865, Milligan's legal counsel filed a petition in the Circuit Court of the United States for the District of Indiana at Indianapolis for a writ of habeas corpus, which called for a justification of Milligan's arrest. A similar petition was filed on behalf of Bowles and Horsey. The 2 judges who reviewed Milligan's petition disagreed about the issue of whether the U.S. Constitution prohibited civilians from being tried by a military commission and passed the case to the U.S. Supreme Court. The case was argued before the court on March 5th and March 13th, 1866. Its decision was handed down on April 3rd, 1866. Prepared by Francis Lieber, promulgated as General Orders Number 100 by President Lincoln, 24th of April, 1863. Instructions for the Government of Armies of the United States in the Field, prepared by Francis Lieber, LLD, originally issued as General Orders Number 100, Adjutant General's Office, 1863, Washington, 1898, Government Printing Office. Article 1, Section 1 of Oregon's Constitution, Natural Rights Inherent in People. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. This is taken from oregonlaws.org.
And what we're dealing with is the real constitutional Republican form of government that we are bringing to Oregon and other assemblies are bringing to their states. And our call to action is we need 45 Oregonians that will stand up under their own name and declare and identify themselves as non US citizens, Oregonians, state nationals, and will sit in a grand jury or in a petite jury and listen to the information brought to them. If they're in a grand jury, to provide a true bill or no bill. If the information coming to the grand jury is bogus, then there's no bill. If it's true, then there's a true bill. And that goes to a trial jury. The trial jury is 12 to 15 people, depending upon how many alternates you have. And those folks are charged with listening to the information and providing a verdict. Now, our court, our civilian court on Oregon, is in common law, which is not the form or law form that they're using currently on Oregon. They're using a form of martial law or admiralty or administrative.
Love the Northwest, and it just grieves me to see how it's changed into the liberal bastion that it has become. When I was in Congress, I utilized 4 questions to evaluate all legislation as well as to draft the legislation that I introduced. The first question is it morally right? Second, is it constitutional according to the original intent? Third, do we need it? Fourth, can we afford it? If all 4 yes, I voted yes. If one was no, I voted no. And that's the way I use that matrix in evaluating all legislation. And while I was there, at least one time, and maybe more, I was rated as the most conservative congressman in the whole of the United States Congress. So I'll appreciate that, Ryan. But we've got to return back to the principles that our founding fathers gave us in the Declaration of Independence and the U.S. Constitution. Neither party are operating constitutionally today. And I'm disgusted with my own Republican Party as well as the Marxist Party. They call themselves Democrats. They've become very Marxist as a national party. And it's got to change. And it's up to we, the people, to make that change. And the only way we're going to do that is for people to become knowledgeable about what government should be, according to our founding fathers. And I highly recommend people to actually read the Constitution. It was not written by lawyers. It's a very short document, and read what they said about it. In fact, I highly recommend, as we look towards the holidays and Christmas, there's a resource called the Federalist Papers in Modern Language. It's edited by Mary E. Webster. It doesn't editorialize. It doesn't make any commentary. It just changes from the old style English into new style English, and then it indexes the Constitution to what a founding father said about it so that you can look at it and see how far we've gotten away from the original intent. We're losing our liberty and freedom, and we've got to demand it again, and that's what I've been all about.
The word secrecy is repugnant in a free and open society, and we are, as a people, inherently and historically opposed to secret societies, to secret and to secret proceedings. We decided long ago that the dangers of excessive and unwarranted concealment of pertinent facts far outweighed the dangers which are cited to justify them. Even today, there is little value in opposing the threat of a closed society by imitating its arbitrary restrictions. Even today, there is little value in ensuring the survival of our nation if our traditions do not abide with it. There is a grave danger that an announced need for insecurity will be seized upon by those anxious to expand its meaning to the very limits of official censorship and concealment. And no official of my administration, whether his rank is high or low, civilian or military, should interpret my words here tonight as an excuse to censor the news, to stifle dissent, to cover up our mistakes, or to withhold from the press and the public the facts they deserve to know. Today, no war has been declared, and however fierce the struggle may be, it may never be declared in the traditional fashion. Our way of life is under attack. Those who make themselves our enemy are advancing around the globe. The survival of our friends is in danger, and yet no war has been declared. No borders have been crossed by marching troops. No missiles have been fired. If the press is awaiting a declaration of war before it imposes the self-discipline of combat conditions, then I can only say that no war ever posed a greater threat to our security. If you are awaiting a finding of clear and present danger, then I can only say that the danger has never been more clear, and its presence has never been more imminent. For we are opposed around the world by a monolithic and ruthless conspiracy that relies primarily on covert means for expanding its sphere of influence, on infiltration instead of invasion, on subversion instead of elections, on intimidation instead of free choice, on guerrillas by night instead of armies by day. It is a system which has conscripted vast human and material resources into the building of a tightly knit, highly efficient machine that combines military, diplomatic, intelligence, economic, scientific, and political operations.
We have formed a common law court, and it's incumbent on us as people to know the different law forms. The one across the street is admiralty law, commercial law, and we are money makers for them from birth to death. They use us to make money in any way conceivable, and we comply because we don't know what else to do. So, to start out with the three basic law forms, there's natural law, which is God-given law, inviolable. It's the law of the land, beyond our common law. It's the absolute law of our Creator. We have common law, which is the law of the land. It started with Magna Carta, and we as people have rights, and we have sovereignty, and we make our own decisions, and that's what the Assembly has decided to establish ourselves and try to insert ourselves as a solution to the admiralty law, commercial law, color of law, which is across the street in the building, and we're here to arraign Kate Brown, Jeff Merkley, Ron Wyden, Jeff Merkley, and Suzanne Bonamici, who've all acquiesced to our notices, and our claims are going to be read today in the form of a presentment. So if you understand or can learn about the three primary law forms, we are common law. We formed our common law court, and we are at the stage now where we offered the presentment. They are supposed to be here to answer and object to our claims, and unless there is one of them here, or a representative of Jeff, Ron, Suzanne, or Kate, please step forward. I see none coming. I'm going to read the presentment. Oregon, without the state of Oregon, within the United States of America, the constitutional Republican form of government. Contact Ronald Charles Ruman. General delivery, Beaverton, Oregon, 97005. Phone number, 503-893-0793. Ron Ruman, 38@gmail.com. Docket number of this claim is, or this presentment, is 03092021A. to let the public know that our court's order to the Oregon True Bill to our Article 3 1 Supreme Court found within our Amendment 7 Common Law Court of Record in the form of a presentment from Oregon Statewide Jural Assembly's Civilian Court of Records Grand Jury. A public arraignment is scheduled outside, and here we are, across the street from 900 Court Street, Northeast Salem, Oregon, 97301 at 1 p.m. It's a good Saturday, April 3rd, 2021, and it's a 4-3-2-1 countdown. Notice to the agent is notice to the principal. Notice to the principal is notice to the agent. To the jury in our Amendment 7 Common Law Court of Record, from Ron Bruman, foreman of the Civilian Court of Record on Oregon's Grand Jury, found at the Oregon Statewide Jural Assembly, Oregon's Constitutional Article 1, Section 1, circa 1859, and Second Amendment well-regulated militia, with unlimited jurisdiction on Oregon. See Liber Code, Martial Law, and Ex Parte Milligan. Our bona fides are in order for perusal. Bless your higher self, all those encountered by or in contact with our court. In Article 3, 1 Supreme Court, claiming original jurisdiction found within Amendment 7 of the United States of America's Constitution, circa 1819 through 1860. We greet you and extend all the best of every good fortune for the good. We are the third-party beneficiaries of this document. We filed this presentment with the jury named in their de jure jurisdiction. Our grand jury found evidence in the public record that each of these four persons, Kate Brown, Suzanne Bonamici, Ron Wyden, and Jeff Merkley, as names they are known by, broke their oaths, have no honor, and cannot occupy a position of trust. Specifically, the United States of America's Constitution's Amendments 1, 2, 4th, 5th, 9th, 10th, and 13th, aka TONA. Additionally, in misprision of felony on Article 7 amended, it was added unlawfully to Oregon's Constitution, November 8, 1910. Fraud vitiates all. They must vacate their offices and draw no more remuneration as of today. We claim Kate Brown and the unindicted co-conspirators on the attached cases docket number 1007-2020A, 1116-2020A, as acquiesced and defaulted to these claims herein attached. We claim fraud, simulating a legal process, violation of due process, to any that infringe upon our unalienable rights as codified by the United States of America's Constitution, circa 1819 through 1860, and Oregon's Constitution, circa 1859. With full faith and credit, governing law is established in this document at this time to be Declaration of Independence, Articles of Confederation and Perpetual Union, Oregon's original Constitution, circa 1859, and the United States of America's Constitution, circa 1859, and ORCP 20A, Clearfield Doctrine, Accardi Doctrine, Ex Parte Young, Ex Parte Milligan, McCarran-Walters Act 1952, Judiciary Act 1789, Section 32. Judgment and neo deceit are all specifically called into this document. It specifically denies any statute at large or treaty until authenticated. Anything federal after 1861 is suspect and needs authentication. Anything connected with State of Oregon or incorporated subdivision, all in caps, and specifically after November 8, 1910, is suspect and needs authentication. These are the governing laws which must be accepted. The DOJ is agent for and to the United States, the entity responsible for the enumerated requirements of Article 3, the one Supreme Court that must claim original jurisdiction to be a court considered to have jurisdiction when found in conjunction with Amendment 7 Court. The Department of Justice for the United States failed. We must do it ourselves. This communique is not intended to mislead, defraud, deceive, or threaten in any way, and is submitted in good faith and with clean hands. We do lawful, not legal, and this is our best effort. On Oregon, without the state of Oregon, all in caps, within the United States of America, the constitutional Republican form of government. Today, in the presence of our present Oregonian, state, national, people on the land of Oregon, we witness for our court's order for the purposes listed. We witness whereof I set my hand and thumbprint to seal this day, 2021.
Kate Brown, Suzanne Bonamici, Ron Wyden, Jeff Merkley as the names they are known by and in their official capacity as the state of Oregon's governor, both United States senators, United States representative. Each of the four persons have violated due process, broken their oath, and have no honor and cannot hold a position of trust. Specifically, violation is a failure to honor a petition for redress of grievance. Through notification of the court's intention, they have acquiesced and defaulted several times, including at their arraignment, April 3rd, 2021. Each failed to attend or send counsel. The trial is set for today. All four of the accused named above failed to appear or attend their trial. We are looking for a verdict in our Article 3, Amendment 7 court. Each is guilty as charged in the claim above. The penalty, using 18 U.S.C. 3571 as a guide, the Department of Administrative Services, Risk Management, EGS, as shown to be the bonding insurance entity for Kate Brown. The bonding and insurance of the other three persons listed above is to be determined. Are ordered to pay remunerations to each member of the Oregon Statewide Jural Assembly in the amount of $250,000 to each member by each of the four insured bonded listed above, or $1 million for each member. The members will be authenticated from the records of the Oregon Statewide Jural Assembly status forms. Each guilty party will be personally liable and responsible to pay the penalty should DAS, Risk Management, or others not pay the penalty. Additionally, Kate Brown is found guilty of filing a bogus stalking order, docket number 0405050011 against Richard L. Koenig, docket 10072020A. Thus, the penalty of $250,000 to Richard for due process violation by Kate Brown. The stalking order and all that ensued from it is a due process violation. Penalty to be determined at a later date, and for the unindicted co-conspirators. Fraud vitiates all, and this court's order removes all known infringements in this matter regarding Richard L. Koenig. Additionally, as Kate Brown, Ron Wyden, Jeff Berkeley, and Suzanne Bonamici have been found to be without honor, they cannot hold a position of trust and are not considered to be bondable and insurable. They must vacate their elected office immediately. Additionally, with the penalty phase to be determined at a later date, Kate Brown, Ron Wyden, Jeff Merkley, and Suzanne Bonamici are all found guilty of misprision of felony with Article 7 amended on docket 03092012A. Notice to the agent is notice to the principal. Notice to the principal is notice to the agent. The jury in our Amendment 7 Common Law Court of Records so declares. The guilty verdict was given to the clerk after they vote for this by the foreperson, who is Tanya.
Okay, so I want to do a poll on the jury. Does everybody find them guilty of what they're charged of? It's unanimous. Okay, so now we have to do each individual one. Charlie?
Guilty as charged.
Guilty of the claims made and the penalty declared.
I believe they are guilty of the claims made, and they cannot hold a position of trust.
Find them guilty for not holding their oath.
In my opinion, and as I believe, they are guilty of all charges.
Guilty as charged.
Guilty as charged.
Guilty as charged.
Guilty as charged. Catherine Enright confirmed guilty as charged.
Guilty charged.
Guilty as charged.
Guilty as charged and without honor.
Guilty as charged. Absolutely no honor.
Guilty as charged without honor.
Guilty as charged without honor.
Guilty as charged.
Guilty as charged.
Guilty as charged.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car. And he's got both his hands up.
And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.